around where we do draw the line on when something is being sold as part of a securities offering. And the response has really been pretty limited. We've given very, very limited guidance. And so I'd like to see us take a more proactive approach where we're actually working with people and we're setting forth what our regulatory objectives are, and then we're working with people so that they can have the exemptive relief they need to both satisfy those regulatory objectives and satisfy their business objectives, and then let the market decide whether or not they like these particular crypto projects or not. I'm hopeful that maybe we'll turn the tide and stop looking to enforcement to be our only guidance.
That was Hester Peirce, the SEC commissioner, hoping the tide would turn at the SEC and that they would stop looking to enforcement being the only guidance. Hey, everybody, it's Eri from Tokyo, and this is your short. I'm going to give you an update on the SEC versus Ripple in less than 3 minutes. Today was all about the filing of new documents. The SEC filed yet another request for an extension of time. They want to extend the March 23rd deadline until no later than 1 week after Ripple files their answer. And then we hear from the defendants where they filed their objection to any further delay. And I quote from the document, "The SEC has delayed resolution of this case long enough," and it goes on to say, "Nothing should further delay Ripple from moving for summary judgment and demonstrating to the court that XRP is not a security." And then yet another document where Ripple and the defendants, Brad Garlinghouse and Chris Larson, filed the response explaining why the Hinman documents are indeed relevant. Now, here's the document that really gets interesting. It's 6 pages long, and it cites that Ripple is entitled to evidence that speaks to the level of clarity. The internal communications, these are these emails, demonstrates that at the time of the speech, that is the Hinman speech in 2018, even the SEC could not have given clear guidance because they themselves did not know. And then in a tweet from attorney Jeremy Hogan, he said there is something in this document that blew his mind. This is the tweet. Jeremy Hogan tried to analyze this in a true legal sense, but it's this part here where Matthew Solomon, who is part of the Ripple defense team, he wrote that the SEC potentially is hiding a document in which the SEC concluded that XRP was not a security. So what does Solomon know? Well, it does seem like he does know something. Now let's hear what John Deaton had to say. So here's attorney John Deaton. If Judge Netburn orders the emails turned over as he believes she will, the SEC has 10 days to appeal to Judge Torres. If Judge Torres affirms or agrees with Judge Netburn, the SEC could try an appeal or writ of mandamus to the Second Circuit to delay a couple of months, but the time is ticking for settlement. What he means to say is that this would allow the SEC a little bit more time to negotiate a settlement, not so much to receive a decision from the Second Circuit. Because if both judges rule the emails must be produced, it is very unlikely they get overturned by the Second Circuit. So SEC will settle, but maybe not immediately. That's exactly where we are right now.